Hi everyone, welcome back to my YouTube channel. In today's video, I will be talking about Physician Self-Referral Law and Civil Monetary Penalties Law. Let's get started. Physician Self-Referral Law. The Physician Self-Referral Law, commonly referred to as the Stark Law, prohibits physicians from referring patients to receive designated health services payable by Medicare or Medicaid from entities with which the physician or an immediate family member has a financial relationship unless an exception applies. Financial relationships include both ownership/investment interest and compensation arrangements. For example, if you invest in an imaging center, the Stark Law requires the resulting financial relationship to fit within an exception, or you may not refer patients to the facility and the entity may not bill for the referred imaging services. Let's talk about what those designated health services are. Clinical laboratory services, physical therapy, occupational therapy, and outpatient speech-language pathology services, radiology, and certain other imaging services, radiation therapy services and supplies, DME and supplies, parenteral and enteral nutrients, equipment and supplies, prosthetics, orthotics, and prosthetic devices and supplies, home health services, outpatient prescription drugs, and inpatient and outpatient hospital services. The Stark Law is a strict liability statute, which means proof of specific intent to violate the law is not required. The Stark Law prohibits the submission or causing the submission of claims in violation of the law's restrictions on referrals. Penalties for physicians who violate the Stark Law include fines as well as exclusion from participation in the federal health care programs. Now let's talk about Civil Monetary Penalties Law. OIG may seek civil monetary penalties and sometimes exclusion for a wide variety of conduct and is authorized to seek different amounts of penalties and assessments based on the type of violation at issue. Penalties range from $10,000 to $50,000 per violation. Some examples of civil monetary penalties law violations include presenting a claim that the person knows or should know is for an item or service that was not provided as claimed or is false or fraudulent, presenting a claim that the person knows or should know is for an item or service for which payment may not be made, violating the anti-kickback statute, violating Medicare assignment provisions, violating the Medicare physician agreement. Other examples of civil monetary penalties law violations include providing false or misleading information expected to influence a decision to discharge, failing to provide an adequate medical screening examination for patients who present to a hospital emergency department with an emergency medical condition or in labor, and making false statements or misrepresentations on applications or contracts to participate in the federal health care programs. This is it for today. Thank you for joining me. If you found this information useful, please consider subscribing to my channel and leave me a few comments. Hope to see you next time. Bye now.